Hello, my name's Kate Bedford, and I'm going to introduce this paper before turning over to my colleague, Silvana. The paper emerged from a piece of pilot research that was funded by the University of Birmingham's Institute for Global Innovation. And the idea was to try and ascertain the impacts of some recent changes to Ecuador's violence against women laws. We were subsequently invited to contribute the research to a special issue of the Latin American Law Review on citizen security. And in the paper, we positioned the pilot study in a set of literatures on citizen security, gender and development, and law and development in Latin America. So I'll start by briefly outlining the interventions that the paper tries to make into those literatures, and then I'll turn over to Silvana, who led the empirical work and who's going to explore the Ecuadorian case study in depth. So the starting point for the paper is to ask what the growing attention to law in development and security in development means for gender equality. Specifically, we wanted to uncover the distinct consequences of conceptualizing gender-based violence as a security and development issue. So we tried to make three interventions into broader debates about the role of law, especially criminal law, in development and security. Firstly, we're trying to move past what Nia Lane calls the lost in translation critique, whereby rather than theorize or critically analyze the demand for more law, legal scholars and practitioners identify the implementation gap and try to reduce it with law plus measures that leave law itself and its role within uneven development, insecurity, and gender inequality uninterrogated. So we wanted to try and go beyond that really limited critique of law to think much more deeply about the relationship between criminal law and violence against women. Secondly, we're trying to gender the discussions of the turn to law within development and security studies by asking what the Ecuadorian example adds to existing work on the state's uneven presence and absence in the lives of underprivileged women. So to do that, we use the concept of the absent present state, crafted in Daniel Goldstein's ethnographic work on Bolivia, alongside other work on state abandonment, recognition, and neglect. So this bundle of scholarship centers the dual role of law and police in everyday insecurity for those who exist outside the protection of the state, but who are subjected to its constraints, such that they can be both abandoned and burdened by the state at the same time. So in line with other work that looks at state performances of protecting women from violence, we highlight the ineffective nature of the courtroom show in terms of supporting survivors, while we trace its other more troubling effects. Thirdly, and finally, we're trying to advance some critiques of carceral feminism. So we're trying to contribute to an empirically informed critique of penal expansion, which accounts for the other downsides of criminalization beyond increasing imprisonment, such as in this case, the loss of forms of protection or assistance for survivors of domestic violence. So to briefly outline the context of the paper, since the 1990s, law has become central to global development efforts to secure democracy, human rights, and markets. And security is a key lens through which the demand for better and more law is mediated. So we see a range of development institutions from the World Bank to UN Habitat, seeing violence, crime, and insecurity as within their remit. Now, in their influential collection on crime in the Global South, Komarov and Komarov link this fetishization of the rule of law and law enforcement to growing anxiety about violence. They note that rulers, themselves often compromised by corruption, stage police dramas and crackdowns when they come under pressure to act in the face of growing violence. So as we note in the paper, the turn to violence and insecurity as development concerns was especially pronounced in Latin America. It also had significant implications for law and policy conversations about violence against women. So until the mid-1980s, violence against women was broadly considered by gender and development scholars and activists to be a manifestation of social inequality best remedied by access to resources and services. So, for example, we see in the pioneering work of Caroline Moser, who's a gender and development specialist and who framed violence and insecurity as development issues. We see in her work that she did not advocate a criminal law first strategy for violence against women. In fact, she decentered criminal law and policy, mostly because the people in her research most affected by violence and insecurity themselves did not see the police as the solution. But by the 1990s, we see a much stronger emphasis on criminal law as a solution to violence against women. We see this exemplified in a flagship 2003 report from UNIFEM on ending violence against women. And there, the measure of progress is that women come forward and demand justice in the form of criminal law, and that governments recognize violence against women to be, quote, not cultural, but criminal, end quote. So in the paper, we show how these criminal law heavy frameworks were in many respects forged within the inter-American human rights system. But the takeaway here is that there's widespread consensus across the region that violence against women is a development and security concern linked to criminal law responses. So we therefore confront the paradox identified by Komarov and others, where the state performs attentiveness to violated women through criminal law in order to restore belief in the state's capacity to tackle violence and insecurity, while the state reduces social services. So in the remainder of this article, we ask what effect this paradox has on survivors themselves. When states show that they're taking insecurity, violence, and women's human rights seriously by advocating penal responses to violence against women, what are the impacts on those women? What do their experiences of the state's uneven presence and absence reveal about the gendered nature of the nexus between criminal law, violence, and insecurity? So in the next section, Silvana is going to talk through how the Ecuadorian case study helps us answer those questions.
Hello, everyone. I am Silvana Tapia, and I am going to present our main fieldwork findings. This work was carried out in Cuenca in Ecuador between January and August of 2019. So just a little bit more information on Ecuador. Ecuador has a serious and growing problem with violence against women. We have an incidence that is as high as 65%. And laws and institutions addressing violence against women have developed dynamically in recent years. There has been an exponential growth, particularly of criminal laws addressing violence against women. And largely due to these new laws, Ecuador has been highly rated by international development agencies, such as the World Bank, in legally protecting women from violence. We conducted 12 in-depth interviews with survivors of violence against women. We also interviewed 6 specialized judges at the specialized courts in Cuenca, 6 caseworkers from a pro bono law clinic, 3 first contact judicial officers, who are the public servants who first see women when they file a complaint. And we also looked at documents, in this case, 80 case files from the same law clinic I mentioned. And we requested some quantitative data from the Judicial Council of Ecuador to get an idea of the proportion of complaints against judgments produced by these specialized courts. And what is probably our main finding is that women approach the courts not necessarily pursuing a conviction, but rather looking for protection. They request what we know as a protection order, which functions in practice as a restraining order. And the problem here is that these protection orders are subordinated to the progress of the criminal trial. If for any reason the trial doesn't reach a conclusion, these protection orders are invalidated. If a woman, for instance, does not attend a hearing, she will lose the protection order because the case will be dismissed. We could tell from the case files at the law clinic that just a very marginal amount of women actually obtain a permanent protection orders. Of 80 case files, we could only find that 4 complaints had received a permanent protection order. We also know from the official statistics provided by the Judicial Council of Ecuador that only a marginal percentage of cases ever reach a conviction. In this case, we're talking about 11%. And the reason why this happens is that women tend to withdraw from the criminal trials. In our interviews, we could tell that women are afraid of the consequences of advancing a criminal trial. They are afraid of retaliation, of stigmatization by their families and friends, and they are also worried about losing the financial support that is very often provided by the aggressor for them and their children. Women often lack the resources, the material resources that are required to pursue a conviction, including transportation, paying for legal advice, because public attorneys usually are not in a capacity to help all of the women who need to file a complaint. Women need childcare, for instance, and also from the interviews, we could tell that there was a clear lack of access to services, including healthcare, social security, financial assistance, and importantly, publicly funded shelters that could act as a safety net for women who need to leave their aggressor. Specialized courts for violence against women in Ecuador are in practice an example of this absent present state that Kate referred to earlier, because these courts are really not connected to services. Women are not redirected to services of any kind when they file a complaint. There is only one shelter for battered women in Cuenca, for instance. It is privately funded and it obviously does not meet the demand. And also, these courts are offering something that is not what most women want, which is protection. Rather, the courts are offering litigation, the possibility of a trial. So the state is there, but in a way that women do not really find useful or meaningful. At the same time, the narratives that lawyers, including judges, caseworkers, and judicial officers bring forward is this idea that women lack legal protection due to their own unwillingness to pursue the trial. And one very common idea is that women reconcile with their aggressors, and that is why they withdraw. This was not the case in the group of interviewees we approached, but this is still a dominant narrative that places the responsibility for lack of access to justice on women themselves. And what lawyers tend to believe is that women need empowerment to learn how to pursue a conviction. Another very important issue here is that police who are competent to hear women when they call during an emergency call, and also when a restraining order is violated, the police is really not responding adequately. Women feel treated either with indifference or with disdain. Very often the police doesn't arrive when it's called, or it just doesn't offer any information or resources that women can use. Therefore, what we see is that this move to criminal law and penalty, which is often brought forward as a sign of taking violence against women more seriously, is in reality undermining protection. And so the effects of criminalization in the domain of violence against women are distinct from those we see in other areas of criminal policy. For instance, here we are not seeing any increased surveillance or incarceration of stigmatized men, which is what some of the literature on carceral feminism argues, because obviously we have so few convictions, there is not that much imprisonment, and also we didn't see any differentiated surveillance of women. What we did see is that this emphasis on the criminal trial is derailing attention from women's material needs. Therefore, our broader conclusion is that if we don't pay attention to the grounded consequences of legal interventions on people's lives, we definitely run the risk of ignoring and veiling some structural dimensions of exclusion, and in this case, women's most substantial and urgent needs. Thank you very much.